morning, everybody, and welcome to Law and Crime. I'm Jesse Weber, and joining me is Law and Crime legal analyst Dan Schorr. We're going to break down the biggest live trials and legal stories in the news today. We have a lot to cover, so let's get started. Dan, this is a big day for the defense because we saw Friday. Curious your thoughts. If they're arguing insanity, they call his ex-girlfriend, they call a friend of his. They talked about how he had a tough life and he was stressed out. I didn't hear about psychosis, delusions, the way that I was thinking I was going to hear. What did you? So today's big, right?
Right, I agree. They were showing that there was stress in his life. He was upset about financial problems, about child custody issues. So that would show why he might be stressed and he might be acting in a way that doesn't conform to the law, but that doesn't show that he doesn't know and appreciate the criminality of what he's doing, which is required for them to win on an insanity defense. So it's really going to be the doctors that are testifying for the defense that are going to try to make that claim. Let
me ask you this. We're getting a breaking development that apparently the defense is moving for a mistrial right now. So they're saying that Anila Lawrence, who again is the defendant's ex-girlfriend who testified, that Friday she told, she said in front of the jury that the defendant told her he never saw a wrong way sign, on the highway. And Bourgoin's defense attorney is saying he never heard her previously say anything like that. Now, his defense attorney is saying that the defense never received a recording of the interview that the state had conducted with this witness, but the prosecution is now saying that they did tell the defense that the state provided this in an unlabeled manila folder with the CD inside. So one side saying they received this, one side saying we did provide it to you. So this back and forth. Is this grounds for a mistrial?
It's unlikely you'll see a mistrial. A lot of it depends on the local state law and how that local court works with discovery. First of all, there's a factual dispute about whether it was turned over or not. But even if it wasn't, the remedy, that's something that might not be a mistrial. It might be that they have extra time to prep the witness or to evaluate the witness before questioning the witness more. So not every mistake becomes a mistrial, but it would depend on how the court locally handles these issues.
Well, let's hear what's going on. We have a live feed into that Vermont courtroom. Let's go live. Okay, let's break down what's happening right now. Joining me as well is trial attorney John Phillips. Now, John, if I understand this correctly, their defense is basically accusing the state of a potential discovery violation. They're moving for a mistrial. What they've said is that when the defendant's ex-girlfriend testified Friday, she was asked about the actual crash, and she made a statement that the defendant didn't know about the wrong way sign or made some comment about that. And they said that after looking through all of the information they have about this witness and what she was going to testify to, they never heard that before. And they said that the state failed to provide them information about this. And the judge seems to be siding kind of with the defense right now and saying, state, how come you didn't actually provide this to the defense? That's what I'm getting. What do you make of it?
I tend to agree. The difference, like most of what I do is civil litigation, and there's some hard and fast kind of playing with terms when you're doing discovery. But when the government, the state is a government agency, and so they don't get to have discretion. They need to turn everything over. And it sounds like they didn't turn everything over, some statements.
Yeah, something that critical. And by the way, the jury already heard it. That's why they're obviously trying to move for a mistrial. They wanted to fight against this, but if they weren't prepared and they didn't know about it, the defense, you could see how they have an unfair they're put in an unfair position. We have quite the development here in Vermont as the defense moves for a mistrial, saying they weren't provided proper information by the state. Dan, as they work that through, the main person they're talking about is the defendant's ex-girlfriend who testified Friday. And we just talked about it. It was kind of surprising seeing her testify because she wasn't that great of a witness for the defense to help establish insanity. But what we just learned during the break as we were listening in is that she was called last minute. What they decided to do is, hey, let's call her ourselves, get all that bad information out about the defendant because she was being planned to be called as a state rebuttal witness. Interesting strategy there.
Yeah, sometimes that's a strategy for either side, that you want to get bad information out on your terms. So if you think the other side is going to raise an issue, you could present it in questions that maybe soften it and get it out there. And they tried to do that. And the issue here isn't just the information from her testimony being given to the defense counsel, but given to the defense experts, because the experts use all information about what the defendant allegedly said to make their determination about whether there is an insanity claim.
Insanity, insanity, insanity. Not easy. I mean, John, you tell me, how difficult is it to firmly establish insanity in Vermont?
It's pretty much the same everywhere. I mean, we just went through this, didn't we, in Tampa?
Well,
And
in the
we
John
saw-
Johnchuk case, yeah, it was, you know what it was? It was insanity, but it's a different standard there. It was a different,
It is.
and the law's a little bit different there. And I'm curious if it's easier for the defense to prove insanity in Vermont.
That's a question for somebody that practices in Vermont. I'm Florida, Georgia, and Alabama. Maybe Dan can help me with that one.
Well, the thing is, and John, really, in Florida, they have this thing called a clear and convincing evidence standard. We have a graphic up right now to see how it relates. In Vermont, it's preponderance of the evidence. My understanding is that is an easier standard. That is a lesser burden for the defense here in Vermont than it is in Florida, and the language is a little bit different as well.
That's a little surprising. Yeah, I mean, preponderance is that feather's weight where it just slightly tips the scales. Clear and convincing, you know, that's clear and convincing. It's more significant. So it sounds like there may be more insanity cases in Vermont than there are in Florida.
Dan?
Well, one thing I want to point out is that burden of proof is for the defense. Usually when we talk about burden of proof, we talk about what the prosecution has to prove beyond a reasonable doubt. So whether it's clear and convincing or even the lower standard preponderance, that's something the defense has to prove. So the defense has to meet that burden, and that's more difficult than a normal criminal case where we just say they just have to show reasonable doubt. So it's not just reasonable doubt that he's insane. They actually have to prove that it's more likely than not that he's insane. Even though that's a lower burden than some states, it's still a burden for the defense that's difficult to overcome.
And it's rarely successful. I mean, we talked about at the beginning of the day when we're going to be entering into the Timothy Jones Jr. case. He's arguing insanity there, and if he's successful, I think it would be the first death penalty case where the insanity defense would work in South Carolina. So let's just jump back into court if we can. The judge is speaking about this defense motion. Remember, the defense is claiming that the state withheld information that they needed to put on a credible defense. Let's see what's going on. Okay, so let's try to understand exactly what's happening. Dan, this is a big moment because when they keep talking about Dr. Kapoor, that is who I believe was going to be the state's expert witness, who was actually going to be called by the defense to say, in her opinion, Stephen Bourgoin was insane at the time. Now, if she wasn't provided this information about what Stephen Bourgoin's ex-girlfriend said, this controversial comment she made on Friday about that Stephen didn't know about the wrong way sign on that highway, then that affects her analysis. That affects her opinion. And if I heard it correctly, the state wasn't even sure if that would have altered her opinion. So does the defense have a point? Could we be looking at a mistrial right now?
They certainly have a point. I wouldn't say it's likely that you'll lead to a mistrial here, but it is an important point by the defense because then there's an expert, whether it's a prosecution or a defense expert, who's making a determination about insanity. They need to see everything the defendant allegedly said to make a judgment about what was he saying right after the incident, what was his account of the incident. So that's really important. Here, the defense is saying that they were denied that opportunity for the expert to review that. But there's other remedies besides a mistrial here. Even if the judge thinks the prosecution did something wrong, they could give an adjournment to give the defense more time to have the expert review that and ask the expert if that would change the expert's opinion. So it doesn't have to be a mistrial.
Maybe instruct the jury on something.
Yeah, there's certainly other remedies besides mistrial. That would be an extreme remedy here.
Yeah, well, we'll have to see which way it goes. It was a big development here on Monday morning. We weren't expecting this. We were expecting to go right into live trial. So let's take a break, and when we come back, we'll see what's happening. Stay tuned.